I think we have a reasonable number of you that have joined now, so let's kick off. Hello everyone, and welcome to today's webinar on the advisory opinions on climate change before the ICJ, Inter-American Court, and the International Tribunal for the Law of the Sea. Today's session is hosted by Doughty Street Chambers and the Climate and Environmental Justice Group in particular, which I co-lead. We've been holding a number of events on climate issues throughout this year. We had an event on climate migration and one on climate whistleblowing and employment. And we'll hold some more similar events in 2024. So for those of you who are not familiar with our group, we are the first climate group of its kind that was set up at the bar to specialize specifically in public interest climate law and litigation. And we work both domestically and internationally. My name is Harj, and I'll be chairing today's webinar. And I specialize in climate law and litigation, and alongside my practice have research fellowships in climate law at the University of Oxford and also at the Grantham Research Institute at the London School of Economics. So I'm particularly excited about today's panel because we have a really wonderful group of experts, and also because I have quite a big interest in these cases. I've been working across the three of them in a number of capacities this year. So I'll just briefly introduce our panelists. So the first is Maria Antonia Tigre, who's the Director of Global Climate Change Litigation at the Sabin Center at Columbia Law School. Maria Antonia is going to start us off with a presentation where she'll be speaking to the advisory opinions as a novel phenomenon in climate litigation. And she'll also offer some thoughts on the Inter-American Court of Human Rights proceedings in particular. Our second speaker is Eran Stoger, and he's an adjunct professor of law at Brooklyn Law School. And he was counsel for Timor-Leste in the ITLOS proceedings and will be acting in a similar capacity for them for the upcoming ICJ proceedings. Eran's going to offer some reflections on the ITLOS proceedings, which had its hearings earlier in the summer this year. Our third speaker is Nicolas Angelet, and he's a professor of international law and a very valued associate member of Doughty Street Chambers, and he's part of our climate and environmental justice team. Nicolas is counsel for the Democratic Republic of Congo before both ITLOS and the ICJ, and he'll be speaking to the relationship between those two sets of proceedings. We have another panelist who has just joined us, Margareta Warinka Singh, and she's an associate professor at the University of Amsterdam and is representing Vanuatu in the ICJ proceedings. And she will be speaking to the ICJ advisory opinion and will offer some thoughts on what that case means for the future of climate law and litigation, both internationally and domestically. So in terms of the format for today, this session runs for 1 hour. So I'll invite each of the panelists to offer some thoughts for up to 10 minutes, and then we'll open up for a Q&A for the remainder of our time. So please put any questions that you have in the chat, and I'll make sure to direct them towards the panelists. So let's start with Maria Antonia.
Thank you so much, Raj. Thank you for the invitation. It's really a big pleasure to be here and talk a little bit about these advisory opinions, as we are really in a very unique moment in climate litigation. So just to contextualize this a little bit, so I manage the Sabin Center's climate litigation database. So a big part of my job is really to, update the database with all of the cases that we see worldwide, and then sort of analyze them and draw conclusions on the general movement of climate litigation. And we publish a report with UNEP every every 2 years or so, which the last one was published in July. So it's part of the way that we sort of analyze this whole movement. And we now have, I think, almost 2,400 cases in the database, including the cases in the US. And obviously, each one of those cases helps push the needle a little bit in terms of the legal obligations related to climate change and the different ways, different legal strategies that have been used to push those and clarify those under national law and international law. But obviously there are, a lot of these cases have been very successful, but there are limitations to them, of course, especially if we look at them from sort of that global perspective, right? Part of the problem is that litigation is expensive, it's very lengthy, and it becomes a very sort of piecemeal approach because we need sort of cases in each jurisdiction and leading with different types of issues to actually advance international law the way that we need to meet the goals of the Paris Agreement. So I think these requests for advisory opinions really come to address part of that problem, right? That obviously we now have a body of law that has been developed through climate litigation, but there's still a lot of uncertainty and a lot of there are a lot of legal questions that remain unanswered, or at least are unevenly answered across the globe. So it is a very unique moment because we do have these very high courts now looking at some of these questions, and some are similar and some are very different, but obviously all of them have this same thread that they will be looking at the Paris Agreement and the UNFCCC and see how that works with their respective bodies of law, right? So, just to sort of put that in terms of like a timeline, I do have something that I prepared in the past that I can try to share here, but it's not updated. But if I can, I don't know if I can share it. Actually, I don't think I can. Oh, I can. Just 1 second. But I'll put it here because I think it's helpful to make sort of sense of it in that way. But so, we had the requests. ITLOS came in December 2022. Then the Inter-American Court of Human Rights, the request was filed in January. And then the ICJ, the resolution at the General Assembly, was approved in April. And the written statements, that's part of the delays that have been made because some of these were extended, but ITLOS was in June, the deadline. The Inter-American Court was extended and now has been extended again. So the deadline is December, I think, 18th. And the ICJ was also extended the first deadline. It's going to be January now. So all of these two processes have been delayed exactly to create the opportunity for more participation. And then at the hearings, we've had ITLOS already, Inter-American Court. These were sort of speculations, but because of these delays, they're not going to be what's in there anymore. But it's expected that the Inter-American Court will happen, sometime in sort of mid 2024, and the ICJ probably after that. And in terms of when these advisory opinions can be expected, it's likely that ITLOS will still be available next year. But then in the Inter-American Court, I think it's unlikely that it will. Well, maybe it is by the end of next year, but if not, in the beginning of the following, maybe others have some inside information that they'll know better than I do. But and then the ICJ sometime in 2025. So, that means that we'll have these courts answering some of these questions on climate change and the responsibilities of states under international law. And, others will talk about ITLOS and ICJ, so I won't go into too many details about that, but I'll talk a little bit about Inter-American Court, sort of the questions that have been posed and how the process works there. The Inter-American Court is a human rights court, for the Americas. And in 2019, there was another advisory opinion that was published by the court that related to human rights obligations related to environmental harm. And the court on that occasion recognized the right to a healthy environment through this interpretation of the American Convention, saying that it was implicit within the American Convention based on sort of different interpretations of the articles there. And that was a big advancement. And the opinion in and of itself was very detailed, very extensive. So I think that sort of led the way to then come to this moment now with this request for an advisory opinion on climate change. In addition to that, the special rapporteur on, I think it's socioeconomic and environmental rights, published along with the Inter-American Commission a resolution on climate change that was also very, very detailed. That's not binding, and the court doesn't have the obligation to necessarily follow that, but it also sort of laid the groundwork for getting to this moment now. So like I said, in January, Chile and Colombia requested this advisory opinion, which is very, very detailed, very different from the requests for ITLOS and ICJ. It has like about 20 questions, I think, and it touches on several different aspects within climate change law, including loss and damage, which was not expressly mentioned in the other ones, environmental and climate defenders. It also will, the Escazú agreement, which was adopted a couple of years ago, because it is a human rights treaty, can also be interpreted within, by the courts. So that's part of the interpretation that's gonna substantiate the answer. And he talks specifically about corporate obligations as well. So it's very detailed, and it has the potential to really cover very widely significant questions on climate change law under the American Convention, but then obviously interpreting the Paris Agreement and the UNFCCC as well. Then another important thing to mention is that the court is generally perceived as a very progressive court. I think this advisory opinion on environmental rights is a statement of that. The court was very progressive in making that interpretation, and it is generally expected that a similar thing will happen with this. It's still possible that the court will rephrase some of the questions. That's something that the court can do, and it did in that other advisory opinion. It was more specifically related to maritime pollution, and so they reframed it to be a little broader. So it might be that they will do that, or they will decide to answer some of the questions and not all of them. But in any case, the court seems to be very open to sort of understanding climate change science as well, and seeing how that will feed into the legal obligations too. Part of what's pretty unique about the procedures at the Inter-American Court is that actually anyone can submit an amicus brief to the court. And that is also part of why they've been extending this deadline as well, because there's really a wide variety of stakeholders that are interested in submitting amicus briefs. So it doesn't it's open to other states that are not part of the Organization of American States, so they can present briefs as well. Civil society organizations are very open to that. So a lot of civil society organizations are actually seeing that as an opportunity to also, bring their views as really part of the process in a way that they wouldn't be allowed to at ITLOS and the ICJ. So it's expected that they receive over 100 contributions, which obviously is very extensive, and they'll receive a significant number of different opinions. Really, the Sabin Center, we at the Sabin Center we submitted our brief already, which is available on the website. If anyone wants to take a look, I can also put the link in here. And I think in the next few weeks we'll see many of the other ones made available. So maybe I'll stop there for now, and we can talk more later on, but maybe to others to talk about the other processes.
Wonderful. Thank you so much, Maria Antonia. There's a question in here which I thought we might just deal with very quickly, and I don't know if you have any thoughts or information on this, but there's a question around whether or not there'll be an extension to the deadline for the ICJ, which is currently at the end of January, because there's been a petition put together by some Pacific states. Do you or anyone else on the panel have any information about that you're able to share?
I haven't heard anything. Maybe Margarita has.
Okay. Lots of heads shaking. Well, yeah, I guess we'll just have to wait and see. So thanks so much. And let's move on to Iran now, who's going to be speaking about the ITLOS proceedings and his work there.
Great, thank you, Harj, and thanks for having me on the panel. I don't know, I'll speak a bit about the experience of Timor-Leste as a small island developing state during the ITLOS hearings and the process in general. I'm not going to talk so much about the process itself or its substance, but just a few short impressions about what happened, and also a bit with a forward-looking view towards the ICJ proceedings. But just to say also that while I am counsel for Timor-Leste, I'm speaking here in my private capacity and not as counsel, and these are my own personal views. Now, one thing I'd like to sort of note is that we are talking about a group of small island developing states, and there's also groupings within those groups, but not all small island states are in the same position. At the beginning of the oral hearings in Hamburg in September, Counsel for COSIS, he counted the small island developing states in attendance on top of those in COSIS, and that included Timor-Leste, and that sort of gave an impression of a united front. And there are, of course, common characteristics, but it's not entirely accurate. And that's something I wanted to point out. So obviously, small island states and others are all suffering from climate change, but they're in different positions. So if, let's say, a state like Vanuatu is very susceptible to sea level rise, it might actually go under, unfortunately, and before that become inhabitable. Timor-Leste, for example, is in a different position. It's severely affected, but those are not the dangers it's facing. So there are differences in terms of actual physical position, but also in terms of the law, there were some differences, and it's important to point out. There are commonalities. So I'll start with that. For example, I think all small island developing states spoke about the principle of common but differentiated responsibilities. So that's the obligations or the higher obligations on developed and high emitting states, that they have more onerous obligations in terms of reducing their emissions. And also on the fact that small island developing states, while not contributing much to the problem, are those suffering the most from these emissions and their impacts. But there are also important differences on the law. So, for example, about how you understood the relationship between the UN Convention on the Law of the Sea and the climate change regime, so the UNFCCC and the Paris Agreement in particular. And so what is the relationship between the two? And also on other issues. So just for an example, so COSIS and Timor-Leste took the view that the tribunal should not go into the issues of the stability of maritime boundaries or baselines due to receding coastlines. But Mauritius, another small island state, did ask the tribunal to go into that. So that was one point of difference. Another thing, as Timor-Leste, as counsel for Timor-Leste, I can say that it was very important for us to stress the right to development and the right of Timor-Leste to develop its natural resources. So, and this is not something that was raised by other small island states. So while there is a group of small island states and they have a very common interest, there are also different views within that group, and that's something that I think we should all be aware of. The second main point I want to talk about has more to do with representation and the identity of the participants. And it's really a numbers game, if you will. And here I'm speaking specifically, it's also true for the written submissions, but specifically for the oral hearing. So if you count in terms of participation, you had COSIS, which is comprised of 7 states. So let's say that's 7 states. You also had Comoros, Mauritius, Micronesia, Nauru, and Timor-Leste. So that is a total of 12 states representing small island developing states. Now that's 12 out of 39 of the group that comprise small island developing states of the UN, so just under a third of that group. And it's also 12 out of 35 participants in general in the oral proceedings, which again is about a third. So here, when you look at the participants, small island states and others, that also explains why there was a big divergence of views in terms of what the law is under UNCLOS. And at least in my impression, and maybe others had a different impression, there wasn't a clear majority position as to what the law is under the UN Convention on the Law of the Sea with respect to climate change. And I want to point this out because there are obviously issues, but I think there's also something to learn in terms of the future proceedings. So of course, one of the big difficulties is resources and capacity of these very small island states and other developing states to have representation, to have the resources and the capacity to appear before these tribunals, and the same will be an issue before the ICJ. There are actors behind the scenes trying to assist these small island developing states and address those gaps, whether in pro bono, providing pro bono services and others, and that's an ongoing effort. But I did want to say that nevertheless, and this is especially my impression also through the involvement in the Chagos advisory opinion, that numbers are impactful. And when a bulk of states align behind a particular position, I think it gives the court cover to go in that direction, even if the court takes a position that would be considered novel or progressive. And beyond that strength in numbers, what was also, again, my impression, present in the Chagos advisory proceedings before the ICJ was also this cross-fertilization of ideas and coordination in terms of which state spoke about what, even within a common position. So a division of labor, if you will. We saw some of this cross-fertilization in the oral hearings in Hamburg. So for example, on a topic of the relevance of the right to self-determination of peoples. So that featured in several pleadings, including Nauru and Timor-Leste. And part of that happened because of conversations behind the scenes before and during the proceedings. But I think we need, moving forward, more of that and better cooperation and coordination among participants. And by the way, not just between small island states or states that have aligned views. I think the more you share your views, the more you discuss with others more in general, even those that you know will not adopt your position, you can still influence those positions and find points of agreement. So I think the more you talk to all other potential participants, the better. And I also think that talking with others, and this, just two last things, talking with others is also, and exchanging views can also help avoiding self-inflicted wounds as well, in terms of small island states' position. So just to give an example, and I think there were more of these, one small island state during the hearing spoke about how in other environmental fields, there are gaps in the law, and then states came together and agreed on new treaties to fill in those legal gaps. Now, when I heard this, to me, it inadvertently implied that the same situation or lacuna exists in the law with respect to climate change under international law at present. And I think that was actually the opposite of what was the point was that was trying to be made. So I think in that sense, it was a bit counterproductive. And I just mentioned it's not a big issue, but I mentioned it as an example because I think the more you speak with others, get feedback on your own interventions and your ideas, the better it is to develop a common position and a more convincing position. States can help each other in their pleadings and in the exchange of ideas. So I hope we see more of that in the ICJ process. And just finally, the last point on a positive note, if you will, from my perspective, attending the hearings, a lot has been said and will be said about the relationship between all these advisory proceedings and the ongoing negotiations under the COP and so on, how they relate to each other, what effect should it have or will it have on those negotiations. Now, one thing I will say, from my impression in the proceedings in Hamburg, is that whereas, in negotiations, it's political, and obviously some states carry more political weight than others and have more influence than others, in the advisory proceedings, what was very evident to me is that the equality. All states are equal. They all have a similar time slot, and they all have a similar voice and the same opportunity to influence the tribunal or the court. And this was also, I think, to an extent evident behind the scenes, because at least somewhat the power dynamics of the conversations behind the scenes also reflected that equality. It wasn't just the big powers of the more influential states talking to each other, but you had to talk with all the other participants if you wanted them to adjust or listen and so on. So I think in that sense, these advisory proceedings are an opportunity for universal participation, particularly in the ICJ, and an equality of arms, if you will. And I think that as a small island state like Timor, that's a very impactful thing for us. So I'll just leave it there.
Thanks, sir. Really interesting reflections, and I think for the lawyers on the call who are involved in these proceedings, I think some helpful reflections on what we can learn from the ITLOS process in terms of collaborating better when it comes to the ICJ proceedings, so as to, I think, kind of maximize the interests of your clients. So really appreciate you reflecting on those issues. So Nicolas, I'll come to you next just to offer some thoughts, hopefully within time, on the relationship between the ITLOS and ICJ proceedings. I think you're on mute still, Nicolas.
Apologize. Sorry, I'm here. Thank you so much for inviting me. The topic of the relationship between the ITLOS and the ICJ advisory proceedings is a complex one, but my main point will be very much in the line of what Aaron has said. We should conceive of the relationship in a dynamic manner. The relation is for us to build. Now, as a starting point, an essential difference between the two advisory proceedings is, of course, concerned with the legal issues to be addressed. In Hamburg, some states who sought to limit the impact of the advisory proceedings argued that the questions asked were overly broad. In truth, however, the questions were very specific, paraphrasing as they did Articles 192 and 194 of the Montego Bay Convention. They were specific and technical, and they were brought before the guardian of the Montego Bay Convention. Many states referred to the convention as the Constitution of the Oceans and to the tribunal as the guardian of the Constitution. Now, all this is prone to leading to an advisory opinion at the effective service of the protection of the oceans and thereby at the service of the fight against climate change. Now, the International Court of Justice, in turn, is called upon to apply a much broader variety of rules of international law, which includes the Montego Bay Convention, but also loose structured rules and principles of customary international law, such as the no harm principle. And I would say that while the court may to some extent be the guardian of the international legal order, it is not specifically the guardian of any of these legal regimes. And so this leads to the complexity of the relationship. First, there is a potential overlap between the two proceedings with respect to the law of the sea, which is at the heart of the ITLOS proceedings, but also part of the applicable law referred to in the General Assembly's questions to the ICJ. And since the ITLOS proceedings have preceded the ICJ proceedings, it will be for the ICJ to shape the relationship between the two, and much will depend on whether the ITLOS opinion will be delivered in time to be considered by the court and by the states and organizations before it. But in any event, it should be noted that the court tends to consider the law of the sea with great appetite, and it should not lightly be expected to leave the subject matter entirely to the ITLOS. In those circumstances, I submit states that have participated in the ITLOS proceedings should not appear before the ICJ as if the issues arising under the law of the sea had been finally dealt with already by the tribunal. States should rather consider repeating or at least summarizing their argument before the ITLOS so that the court may take it into account when it will decide to address or not to address some or all aspects of the law of the sea. I think it is important for states in the first round of their observations to plant their flag in this respect. But it is too early to say whether states should then, during the second round and during the oral pleadings, invite the court to stay aloof from the law of the sea or to confirm the tribunal's opinion or to specify or nuance it in one respect or the other. That will depend on the outcome of the Hamburg proceedings, on when they become available, and of course on the position of any given state with respect to that outcome. Irrespective of differing national interests, however, states which value the international legal order should try and make sure that the opinions from Hamburg and The Hague mutually reinforce each other. And this is something we will have to work on. So much for the risk of overlap. Now, second, then, there are more areas of the law where there is no important risk of overlap. Some of these, such as due diligence, will inevitably be addressed by the court. The court cannot answer the questions asked by the General Assembly without addressing due diligence. But in other respects, the ICJ will have far more leeway than the ITLOS to pick and choose between many topics to lay emphases as it deems appropriate. Now, some states, for example, may wish to obtain an opinion on rights and obligations of states in the economic sphere, such as international investment law. Some states may wish to obtain an opinion on extraterritorial jurisdiction. These are all topics the court can address, but will not be obliged to address. And yet, some of these topics may well be the most important ones in order to maximize the specific nature and thereby the effectiveness of the court's advisory opinion. In these circumstances, you've heard it from Aaron, but hear it from me, like-minded states should try and work as a team. First, coordination is needed to flag the issues and to guide the court in the exercise of its discretion. Like-minded states should bring and repeat the same message to evidence the interests, if not of the international community, then at least of a part of the international community in obtaining guidance from the court on any given subject. You've heard that from Aaron, but you see, we are already practicing what we preach. We are repeating the same message and speaking with a single voice. So first, coordination is needed to flag the issues, and then, of course, coordination is needed to flag the answers. And third and last, coordination will be needed indeed to make the best of the very limited amount of time that will be allocated to each state in the oral pleadings. Pleading time was very limited in Hamburg. It will probably be even more limited in The Hague. And if each participant consumes its 15 or 30 minutes in splendid isolation, nothing useful will have been said at the end of the day. Therefore, like-minded states must allocate the topics between themselves to make sure each important topic is addressed in some depth. And therefore, my conclusion is this: the relation between the two proceedings is, to a large extent, also for us as lawyers to make. We must very actively consider how to make the best of the similarities and of the differences between the ITLOS and the ICJ advisory proceedings at the service of the fight against climate change. Thank you, and I hope I haven't been too long.
Thank you, Nicolas. No, that was wonderful and timely, and I'm glad that we're developing a consensus, it seems, in terms of how to go about doing this work. And I think your final point there about the emphasis being more on the lawyers rather than the courts themselves in terms of finding consistency is the right point to be making. So thank you again. So we'll come now to our final speaker, who's Margareta, and she will be speaking to the ICJ proceedings and potentially offer some thoughts on the future of climate litigation as well.
Thank you very much, Harj. And it's good to be last because I feel that much has been said. I very much agree with everything that has been said by my fellow panelists. So I'll offer some complementary thoughts, which are maybe even a bit more forward-looking. And I'll offer these thoughts based on the assumption that the ICJ delivers a helpful advisory opinion. And Nicolas, I couldn't agree more with you that it's much of that. Whether that actually happens depends on our own hard work, as of course, as well as a wide range of other factors. But there's definitely a lot that can be done by the legal community to make sure that these processes deliver. So let's assume that they do. How could that then affect the future of climate litigation? And again, I'm going to assume that the glass the glass is more than half full, so to say. So broadly speaking, when it comes to the ICJ, it's about making international law more actionable in climate litigation. And in part, that is because of the stature of the ICJ, of its symbolic authority, as well as of the process of legal mobilization that is very much ongoing. That started already, of course, as soon as the diplomatic campaign began for in the UNGA to get the resolution adopted. There is a whole lot of activity that has been in a way triggered by first the campaign, now the request, and the ongoing proceedings. So there are dozens of scientists and lawyers involved in preparing submissions, putting together evidence. And so that is, in that way, the legal community really engaging with the problem of climate change, and doing so through a lens of international law, of obligation, of legal consequences that has been specified by the UN General Assembly. And very importantly, that was a product of intense negotiations. And because we have a consensus resolution, there's also a consensus on the framework that is being applied, or the lens through which we look at international law when thinking about climate change and responsibility. So that's just to emphasize that it's not just about what is going to be put down on paper by the ICJ, and what is going to be opinion and dissenting opinions, etc. But it is also about the process. But let's now focus on the opinion itself, what the law and what the interpretation of the law is going to be as per the ICJ. So ideally, the ICJ will clarify, of course, what exactly international law requires of states as per their existing obligations. And here, I think it's very clear, even from this panel itself, that there is a landscape wherein every court or tribunal has a very distinct role to play. And we are hoping, of course, that the roles that these bodies that engage with climate change And of course, that's even also other UN human rights treaty bodies, for example, and other bodies that are engaging with international law as it applies to climate change. But these are distinct roles. So what the very distinct role that the ICJ plays is one of accord with general jurisdiction that has been asked a question by the General Assembly that is quite broad and that deliberately invites the ICJ to take an integrated approach to international law. So that is also a very important part of the envisaged contribution, that the ICJ will look at this kind of tapestry of legal instruments and obligations, as well as customary international law, and make sense of it all. And in that way, hopefully strengthening what are understood to be obligations under the climate change regime, under the convention, under the Paris Agreement, as well as making explicit what is now still largely implicit when it comes to human rights treaties. That integrated approach, if it is done well, ultimately leads to a strengthening of all these disparate obligations. And to take human rights as an example, much has happened, to make an understatement, when it comes to linking human rights with climate change. We have a whole series of Human Rights Council resolutions, statements from treaty bodies, many reports from the Office of the High Commission of Human Rights. Well, I could go on and on, but still it's a lot of discourse. And when it comes to really showing that we're dealing with obligations, hard obligations, there are a few judgments that have been delivered by domestic courts, which have been very influential, and not to take away from that, but the ICJ pronouncing on these obligations, clarifying them, would be development that could give climate litigation domestically all around the world a significant boost. And then to wrap up, because that will give us some more time for discussion, one point in this regard to highlight is the potential of the ICJ interpreting these obligations in a way that has due regard to past, present, and future. And that could be perhaps the greatest contribution that the ICJ could make, because most of the judgments, the really landmark decisions that we have seen coming from domestic courts thus far, are doing they're either very forward-looking or they're looking at the past, although we do not even have a single judgment that properly looks at the responsibility of states for the consequences of their past emissions that are being suffered today. So the most impactful judgments are about preventing future harm. So the ICJ, because of the way in which the question has been phrased, has a unique opportunity to show how these obligations to, on the one hand, prevent future harm as a matter of customary international law, obligations arising from different environmental treaties, the climate regime, as well as human rights law, how these obligations are about protecting human rights in the future, preventing future harm, as well as dealing with losses and damages or injury, or however it's phrased, depending on your lens, how these need to be addressed in accordance with international law. And so that is really state responsibility. So that is the second part of the question that has been posed to the ICJ. And it is there where climate litigation thus far has not really, I think, shown its full potential. There's a lot of ground to gain. So I think that is an area where the ICJ could provide very helpful inputs to the climate litigation movement, so to say.
Thank you so much, Margaret. A really fascinating set of reflections there. And the point you ended on around the failure, I think, of the climate litigation movement or the cases to meaningfully deal with historical responsibility is a fascinating one. And I think there's some work being done now, which I've been a little bit involved with around the concept of climate reparations, which is, I think, distinct from loss and damage, which is about present and future harm, but is more backward looking. And some scholars have started putting some numbers on the climate reparations that are owed by individual companies in any given year. So hopefully we'll see that developing in the future. Okay, so we have 13 minutes to try and get through a lot of different questions. I'll try and curate them a little and direct them according to the conversation we've had thus far, and I think the expertise that we have on this panel. Maybe just a very quick one to begin with that I can deal with. There was a question around judicial capacity, essentially, and whether or not judges have been receiving any type of climate training on climate law or indeed climate science. I will share that I've been involved in some of that work with the Asian Development Bank. They've got an established program for training judges in South Asia and Southeast Asia. And there's been some engagement with judges in the courts that we're discussing, but I think it's a valuable point which speaks to not only the substantive understanding of judges, but also the judicial politics and the nature of decision-making, which is something that as lawyers we have limited control over, but is obviously a very big part of what will happen with these cases. But to dive into another issue, we got a question around whether or not the advisory opinions will address the issue of state responsibility for climate displacement. So I might point this one towards Maria Antonia, given the sort of breadth of the Inter-American Court questions and also the scope of the ICJ questions as well. How will this issue of climate displacement show up, particularly in relation to some of the human rights related questions that the court will be answering in the Inter-American Court proceedings?
Yeah, so for the Inter-American Court, there is a specific question related to that. So unless the court, like I said, changes a little bit the scope of the question, it's very likely that they will specifically address this. The question relates to impacts on people such as human mobility, migration, and forced displacement, and effects on health and life and loss of non-economic assets as well. So like I said, it's very, very specific. And then they also ask about obligations and principles related to non-voluntary human mobility exacerbated by the climate emergency too. So it's very likely that they will, in fact, address that issue.
Great, thanks. And I think as those of us who've done some work in this area know, obviously the Refugee Convention is not an instrument which can deal with this issue of climate displacement. There's no real capacity to recognise climate refugees. So I think that the Inter-American Court advisory opinion in particular will be quite consequential for dealing with that very complex issue. So we have another question on the risks associated with these advisory opinions. And we had a separate question which was speaking to what are some of the dynamics about that are connected to these opinions occurring simultaneously. The question we received around the risks was in relation to essentially what happens to climate litigation if we have regressive or conservative decisions being made in the advisory opinions, or indeed you have a splintering of international law with divergent principles being established by the different tribunals. Maybe I'll go to Margareta on this one. Obviously, this is a risk which the people behind these cases sort of contemplated. But what is your assessment of the prospects for climate litigation as a field if we get an unhelpful decision from the ICJ or any of the courts?
I'm probably the wrong person to pose the question to. So let me start by saying that no worthwhile initiative is without its risks, and of course risks have been very carefully mapped out and considered, and then again I'm the wrong person to ask because I'm optimistic and obviously think that the risks are manageable, but do require consideration and work. the risk, they're wide ranging, obviously, right? They start with the first risk at least as far as the ICJ is concerned, was not getting through the UNGA, at least not that hurdle has been crossed. But then the next one would be the ICJ declining to deliver to exercise its jurisdiction, deliver an opinion. That risk, we believe, is very small. But then again, we need to consider the factors that could result in that outcome, etc. Then there would be a risk of basically denying, not going along with the science, not being convinced by the science. Also seems a very small risk. And then you get to the merits and what could go wrong there. Regressive statements, contradictory statements. So yeah, again, I think Nicolas, your point, also made by Aaron and Maria Antonia, that much depends on the arguments that are being put forward by states and also the wider international law community, what is being published, what is even being discussed informally in circles where those who are engaged in proceedings move around in. Though all of these factors matter in terms of producing interpretations ultimately that are going to be helpful. And so another risk that is mentioned sometimes relates to the scope of the question. So there's I think a school of thought that believes that having a broadly formulated question creates a risk of a useless answer because the court's opinion would be so vague that it would be meaningless. That's a school of thought. I personally do not belong to that school of thought, or in the sense that I think that the questions that have been posed to each of the courts and tribunals are sufficiently specific to provide very good chances of helpful outcomes that are sufficiently specific. But again, it requires that the court is served with also sufficiently sophisticated and specific answers that then result in those in an interpretation can again be utilized in domestic courts. I'll leave it here, and perhaps other panelists have other points to flag or share.
Thank you. Unless anyone wants to come in on that, I might move to another question. So we received one here about remedies and the remedies essentially that the ICJ or the Inter-American Court is capable of ordering. So in the Inter-American Court context, these are advisory proceedings, so it's not a contentious case. You don't have remedies being ordered by the court. But I think it's a relevant question, particularly for the Inter-American Court, given the extensive powers that court has to order things such as for states to change their legislation, but quite extensive powers compared to other international and regional courts. So I might put this question to Nicolas, which is around the capacity, the structural capacity of different courts and tribunals to order remedies in international proceedings. How much is that informing your thinking when you're working on these cases, and how much do you think it will inform the judges' thinking when they're writing the decision?
That's an important question indeed. I myself tend to believe that whether the court has the power on or not to order specific remedies is not necessarily determining. What seems the starting point is to consider, or the implicit idea is that without an order of specific remedies, the judgment is not effective, right? I think that or an advisory opinion can be effective if it is specific. That was the point I wanted to make a few moments ago. It's like soft law and hard law, or indeed, as Mathias Forteau pleaded for France in Hamburg, the difference between obligations of means and obligations of result. One can have an obligation of result or hard law, which is very vague, therefore not effective, and one can have soft law or an obligation of means which is very, very specific, therefore effective. And I think that the advisory opinion, even if it's not formally binding, will be extremely effective if it is specific. And that is why I as a counsel, I try to obtain as specific findings as possible. The more specific they are, the more it will be possible to rely on them in domestic courts, to rely on them in domestic parliaments, etc., etc. So that is my view. Specificity is more important than legally bindingness.
Thanks so much. Yeah, that makes a lot of sense to me. And I think it's one of the nuances in the way in which international law operates, which I think domestic practitioners sometimes don't fully grasp, and which I think is a less obvious attribute of how international law functions. We've got a few more minutes, so I'll lob one question at Iran, and then we'll leave it there. So we got a question here about science, which is obviously a very big part of understanding climate change, both as a phenomenon, but also in terms of some of the legal and substantive issues that courts are having to decide on here. As lawyers, most of us are terrified of science, and so I don't know if you're in this category, Iran, but judges are often more fearful as well. So how have you thought about scientific issues in your work for Timor-Leste, either in ITLOS or in the ICJ proceedings?
Well, thanks, Harj. I'm slightly scared of science, but I'm terrified of math, as most lawyers are, so this is a bit better. I think one of the positives that could come out of this process, whether in ITLOS or the ICJ, is the consensus about science. We did actually see that in ITLOS, that with very few exceptions, there was a consensus that the scientific community is of a particular view, which is reflected in the IPCC reports, and states accept that particular view, and that's not a contentious issue. And I think one of the positives that could come out of the process, whether in ITLOS and the ICJ, is a form of legal or judicial seal of approval on the scientific consensus. In some places in the world, more than others, perhaps that's still being challenged. So that, I think, is one positive that can come out, and that would be a basis to go to Nicolas' point before. That would also serve as a basis for any future litigation, that consensus. I think one of the key issues, just to speak about the challenges of science, that one of, I think, the more contentious issues that was evident in ITLOS, and this was also something that Timor dealt with, is the relationship between the clear scientific picture, whereas if we don't reach the objective, the goal of 1.5, it's going to be horrific, and whether that then equals a legal obligation to reach that, however that may look in terms of individual states' actions. And that was really the heart of the contentious. And one state even said, you know, science is not law, in the sense that states make law, scientists make science, states make law. So that relationship between what the science is and the consensual view of the science, and how that relates to legal obligations, is critical. And I imagine it will repeat itself in the ICJ in terms of a focus. So yeah, I'll leave it at that. Maybe just to add one more point about stuff that was said before, in terms of whether the courts will address issues like climate refugees, for example. It goes back to what Nicolas said, that they can address it. I'm talking here about the ICJ specifically, can address but not obliged to address. And this goes to Nicolas' point, where as the more states make it an issue in their submissions, any issue, the more the court, the higher the chance the court will have to deal with that issue in its advisory opinion. So that goes to what Marguerite, Nicolas said. A lot is dependent on the state's positions and submissions and what they're asking the court to do.
Great, thank you so much, Iran. Nicolas, I'll come to you, and then Maria Antonia, and then we'll have to wrap up.
Thank you. Just a short point on science as well. Obviously, the IPCC is a treasure to handle the relationship between science and the lawyers, but mostly, as Margareta discussed, for the future, for the prospective issues of what we have to do to save the planet, much less so for the back-looking issues, how do you call them, of responsibility. There are still huge issues of scientific evidence to establish responsibility. And therefore, I think that this is something we must address as lawyers. Science will help us ultimately when there will be more evidence of causal relationships between some facts and some damages. But before that, we should be inventive, or perhaps not even inventive, but apply the liability regimes that allow us to address the difficulty of establishing causal links. I'm happy to discuss this further.
Yeah, it's a wonderful point. Yeah, and I'll just add briefly on that. The research group I'm a part of at Oxford, the Sustainable Law Program, is an interdisciplinary group with climate scientists, and some of the research that's being produced there goes precisely to these questions of historical responsibility. The attribution science field has become incredibly sophisticated, and we're now getting to the point where there's some research I've seen which is attributing warming to specific actors and not just to sort of climate change itself. So that'll play obviously a very important role in liability in the future. Maria Antonia, I'll come to you.
Very, very briefly, because I know we're out of time, but also on the science, I think we need to mention that our brief to the Inter-American Court actually touches a lot on that, and a lot of it is based on the work of Michael Berger and Jessica Wendt, who I work with, and they do a lot of work on climate attribution science and how that reflects in law. And I think part of what they have said in the past is that there is no, I think, as far as we don't know in fully detail all of the 2,400 cases in the database, but as far as we know, there has been no court that has actually denied the science of climate change. Obviously, cases have been dismissed or been unsuccessful for other reasons, but I don't think the science has ever been challenged in that way. And then just wanted to briefly mention, that I think another important thing for these courts to recognize too is, how science is constantly evolving as well, and make sure that whatever we decide in terms of law actually takes into account that the knowledge that we have on climate change is constantly evolving. And I did have something else to say, but I forgot, so I'll leave it at that.
Thank you so much. Okay, well, I obviously find this topic fascinating, and I would love to stay here and speak with you all further, but unfortunately we have to wrap up. So I'd just love to thank again all of our wonderful panelists. We really appreciate you making the time to contribute to this topic. I've certainly learned a lot, and I hope that everyone listening has as well. So yeah, I'll leave it there, and I'll just say that within Doughty Street, we have a lot of colleagues who are working across all of the advisory opinions within our climate team. So if anyone would like to reach out and learn more about our work, please feel free to do so. But thank you very much, everyone, and have a great day. We'll leave it there.
Thank you very much. Goodbye.
Thank you so much.
Thanks, everyone. Bye-bye.